so-called arrest or fraud.
That weakens the weight.
Very well.
I don't think we...
No, my lord, I just want to bring it to you
okay.
that those depositions should not be responded to.
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter. But you can't, don't say we should expunge it.
My lord, the respondents say they had already done the collation. That is the point you considering our very well.
I don't think we...
No, my lord, I just want to bring it to you that those depositions, where there was a pending injunction application against the Electoral Commission, that my lord,
my lord, so far various allegations have been made in this court in the course of his submissions, which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel. We have a...
Please restrict yourself to your affidavit and let's go on.
Yeah.
yes, my lord. So,
we don't have
my
the whole
lord,
day.
my lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us 2 days.
My lord, this is not before the court.
Okay. So you haven't deposed...
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My lord,
you were addressing us on what you said is the argument that the declaration has been done already. So address
my
us.
lord, our quick response is that, in fact, in the Hawa Yakubu decision, orders were made. It is deposed to the fact that our second to 7th.
The 7th paragraph is a was there. I don't know what to look at here.
I think there are cases that the court gave you a hearing.
Yes, that's the word I'm responding to. And I'm saying that we were not here.
So it's different from saying that
We were not here. And Lord, nowhere in my Lord's did he even say with respect that he read our agenda and dismissed it. Nowhere. In fact, he himself said, you will not allow the agenda to affect the pre-hearing of the application. How can I say my agenda is being to affect?
no, he said he gave you a hearing on the application.
Yes, my Lord, and that is what we are saying.
So it's not a joiner. He had before him an application for mandamus.
No,
And there are cases that when you appeared, he had you on the application for mandamus.
no, my Lord.
No, I'm trying to make you to understand their case. But what is it? They are misrepresenting their case.
So, my Lord, the point we are making is that we were never here on the application for mandamus. Because first we were praying that we felt the joy. Then we never.
Something.
Owusu a 3 years exhibit. I think it's a the one in respect of Nana Akua Owusu a 3 year.
My Lord, I want to just locate mine.
I believe it's yours as a PC.
Okay. No.
The original application is located.
Okay. Yes,
You found that?
yeah. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but it's fine. But the one in respect of Nana Akua Owusu a 3 year.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
Can you read it?
yes, the application of on the face of it is not different. And notwithstanding the submission of a friend of the court in the person of Godwin Kuju Ebiji Tamaklo to the effect that the winner of this constituency has been declared. And he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission.
No, the submission is to draw his attention of the pending joinder and the judicial review. And notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
But you were not you were not a party to the application. Perhaps that was why he decided to describe you as such. Yes.
No, my lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my lord, just to draw his attention.
Anyway, we still have two other lawyers here. So
my lord,
you wind up.
My lord, on this basis, so my lord, this court has on many occasions upheld the fact that the person to be affected by an order or a decision should be heard. My Lord, within this context, a failure to do that, my Lord, will be a serious affront. That affront to the rule of law, constitutional the other party. The Supreme Court, and my Lord, I conclude here. The Republic versus Court of Appeal, Anthony Tomford, ex parte Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atuguba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the Odi Alterum Partem rule involved. That Odi Alterum Partem rule has been elevated to constitutional pedestal, and this breach has constitutional consequence. My Lord, and said breaches void the act in question. My Lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Counsel for
Yes, my lords, we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court General Justice 13 just saying that Electoral Commission go and perform and complete your constitutional duty. None.
Oh, you mean the individual applicants?
Yes, my lords. There's none before you. They have not deposed to
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. He's an artificial person. These are individuals. The first applicant will not go to Parliament. It are individuals. They are before you. They have not said anything. My lord, well, he said he has sponsored. Let the sponsorees, it's the sponsorees who go into Parliament, not the sponsorer. My lord, the second point I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. Another civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my Lord presiding and his brother now retired Justice Badegbe delivered a ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my Lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read. of CI 47, my lords. No proceedings shall be defeated by reason of misgender or non-gender of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
But it was not a writ. Why do you
No, that's why I use the word even if.
Okay.
Even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore certiorari should lie. Respectfully submitted. Thank you.
Oh, counsel.
Right.
But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No.
No,
my lord, the order at hand an injunction placed, but in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-gender, but you can question it on other parties.
Yes, my lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my lord. And then also, one last thing. Now that you have brought it up.
Gender was heard.
Yeah, that's their case.
That our agenda was heard and dismissed.
Yes.
My lord, with the greatest respect, the gender application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about you. What you are alleging, my lord, is not captured in affidavit.
Is that paragraph what?
To the paragraph where you said the joinder was heard. A joinder which was on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. And I'm saying that we were not heard.
So it's different from saying that the
Very well.
judge
We were not heard. And my lord, nowhere in my lord's ruling did he say, with respect, that he heard our agenda and dismissed it. Nowhere. In fact, he himself said he will not allow the agenda to affect the quick hearing of the application. How can that same agenda be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my lord, and that is why we are.
So it's not a joinder. He had before him an application for mandamus. And their case is that when you appeared, he heard you on the application for mandamus.
No, my lord.
No, I'm trying to get you to understand their case. Because you are misrepresenting their case.
Very well. So, my lord, the point we are making is that we were never heard on the application for mandamus. Because first we were praying that we'll first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akuya Owusu Afriye.
My Lord, I want to just locate mine.
I believe it's Leo's B series.
Okay. No. Okay. Yes,
You found that?
yeah. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but fine. But the one in respect of Nana Akuya Owusu Afriye.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
Can you read it?
yes, the application of on the face of it is not different. And notwithstanding the submission of a friend of the court in the person of Godwin Kuju Ebiji Tamaklo to the effect that the winner of this constituency has been declared, and he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission.
No, the submission is to draw his attention of the pending joinder and the judicial review, and notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
But you were not a party to the application. Perhaps that was why he decided to describe you as such. Yes.
No, my lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my lord, just to draw his attention.
Anyway, we still have two other lawyers here. So
my lord,
you
so,
wind up.
My lord, on this basis, so my lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My lord, within this context, a failure to do that, my lord, will be a serious affront. That affront to the rule of law, constitutional the other party. The Supreme Court, and my lord, I conclude here. The Republic versus Court of Appeal, Anthony Tomford, ex-party Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atibuba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the Odi Alterum Partem rule involved. That Odi Alterum Partem rule has been elevated to constitutional pedestal, and this breach has constitutional consequence. My lord, and said breaches void the act in question. My lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Counsel for.
Yes, my lords, we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court General Decision 13 just saying that Electoral Commission go and perform and complete your constitutional duty. None.
Oh, you mean the individual applicants?
Yes, my lords. There's none before you. They have not deposed to
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. It's an artificial person. These are individuals. The first applicant will not go to Parliament. It are individuals. They are before you. They have not said anything. My lord, well, he said he has sponsored. Let the sponsorees, it's the sponsorees who go into Parliament, not the sponsorer. My lord, the second point I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. And now the civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my Lord presiding and his brother now retired Justice Badegbe delivered a ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my Lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read.
CI 47.
Of CI 47, my Lords. No proceedings shall be defeated by reason of misgender or non-gender of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My Lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
But it was not a writ. Why do you try?
No, that's why I use the word even if.
Okay.
Even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore certiorari should lie. Respectfully submitted. Thank you.
Oh, counsel.
Right.
But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My lord, the order had an injunction placed, but in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my lord. And then also, one last thing, now that you have brought it up, my lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my lord will look at it as an application. My lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you. My lord, let me give you.
Counsel, take your time.
Oh, my lord. Well, my lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it. But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my lord, to wrap up, none of the applicants before the court has made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimako.
My lords, we are also opposed to this application. We filed a freedom position case on the 25th of December 2024. We rely on all the positions made in the affidavit and the exhibits attached. And the authorities listed in the statement of case. My lords, this application on the document of the court, which all parties to the action were not served with a said application at the time when you were dealing with the mandamus application. My lord, we submit. The application for joinder was indeed a non-starter. That is because, my lords, there are specific rules dealing with mandamus application. And my lords, in Boyfio, this is 8 years for properties. Boyfio, this is 8 years for properties. 1996, 97. IGLR 531 at 533, this court held that the law was clear that where an enactment, where an enactment had prescribed a special procedure by which it was that procedure alone that was to be followed. Malos, Order 55, Rule 5.2 has provided for the procedure by which notice of an appeal for judicial review can be communicated by the court to any affected party. That procedure is not joint application. The court may order that notice, and it is may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion of the line, it is desirable that the person should be given notice. It is a rule, my lord. It is a rule, not by joint application. And my lord, this is a discretion which a court has to exercise. It's a discretion. It's a discretion. And if a court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
Alos, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, Espati Chatushikata, 2005-2006.
Oh, read the report.
Read the report.
If you have the report there.
Yes, yes. The clear thinking of this court is that.
What page are you quoting?
Well, page 619. 619.
Yes, yes.
The clear thinking of this court is that House Supervisory Jurisdiction and Article 132 of the Constitution should be exercised only, in the word underlined, only in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the application a complete nullity. My Lord, if I may even
now, I get the point, but you see, you would agree that the ex parte Chachuchikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the odi alteram party. So, yes, if it comes, your point holds. But also address the area of the failure to observe the odi alteram party rule.
Yes.
You have argued it, but I think you should expatiate on it.
My Lord, we stop it. That a non-party to a suit cannot complain. That his right to fair hearing has been breached. In this case, my Lord, I saw the Republic versus High Court, Accra. High Court, Accra. Ex parte, Danso, and others. (2015, 2016), one LGLR at page 760. 760. One Supreme Court of Ghana law report at page 760. Holding one. Holding one. This court held in dismissing application for judicial review as follows. That instead of the first ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak. My lords,
but there are several decisions. Republic versus Collegono Magistrate, ex parte Amponsa, which has been cited by Amenuvo. They said that as for certiorari, their public law reliefs, you don't have to be a party. And then we have
it's about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Ex parte Adavali and so many other cases.
Yes,
but make your point.
Yes, what else? So the point we are making is very simple. The High Court only made an order directed at the public body to perform public function. To simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, who the court made for the EC, the first to go and collect and declare who has won or who has lost, my Lord, it's a public function. It's a public function. How does that order to go and collect and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
My Lord, maybe D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation sheet.
Yeah, it's a public document.
It's a collation sheet.
Which is a parliamentary election result summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the coalition and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My Lord, with all respect.
Because they have a right, even at the administrative level, to object.
Yeah, my Lord, under the CI 127.
Yes.
if a party decides not to participate in the process,
Yes.
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There is nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My lords, with all respect to you, to the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted, and you want to challenge the result of an election petition. Petition, my lords, with respect. At the time when the court was making an order for Madam's application, it exercise I don't know if effective. But now, personally,
No, I'm just trying to say that what the applicants are saying is that they stood to be affected, and you are saying that they would not be affected. Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Milbo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you, but it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my lords, I mean, this particular exhibit D6, 7, 8, and 9 is contained therein were not factored in at the time when the court making an order that proceed to go and do collation and declaration.
Okay. Agreed.
Mr.
Melbo, if you have...
My lords,
Yeah, that's right. No, just one point. Mr. Melbo, if you have those exhibits, I think you should check them well, because D10, the form there is a bit different. So it will be of interest to you.
Ma'am.
You know, the D10, the form doesn't contain the portion for stating the reason why you will
Yes,
not
my lord. I
So it's of interest to you.
Yes, my lord.
Okay, thank you. Yes, Mr. Gary.
Yes, my lord. So, my lords, clearly, the point I'm making is that if there's public elections are being conducted in all polling centers, not declared in all polling centers, what is left is collation and declaration, summation of the various results in the various polling stations. Why should it be a problem, my lords? Why should it be a problem? Why should why should the EC? So, my lords, the point that we are making, granted without even admitting that the application for joiner, which we have said, my lords, but the rules don't provide for joiner applications. If the judge has been aired, granted without admitting, the judge has been aired, the recourse of the petition of the applicant is appeal, not judicial review. And it also should arrive. I just have to do it before you this morning. My lords, again, one other friend made a point about where's the rules book? About we not filing a statement of case. Thereby making the application and the judge being biased. Refer my laws to Order 55. Two, 3, of CI 47. That within 14 days after filing, face of the application, the applicant shall file such copies of the case as the registrar shall determine, setting out fully arguments he wishes the court to consider. My lord, is the registrar. The registrar. Now, if the applicant does not file a no case within a time stipulated under Sub 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing, restatement of case, deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desirous to do so, made no such order. In any event, my lord, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, they did not oppose the application. They took the view that yes, they wanted to go and do their work. And indeed, my lord, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed.
Oh,
Foreclosed.
If that were the law, the illegality will persist forever.
My lord,
So I'd like your other arguments, but as for foreclose,
my lord,
your other arguments you have answered substantive.
my lord,
Yeah.
my lord, an order by a court to proceed to perform a constitutional and statutory function.
If it's set aside, that would be, the consequences are clear in the authorities. Anyway,
With respect,
yeah. Your other points I will
If
take,
I may-
but as for this one,
Yes.
yeah.
further, my lord, it is not the applicants, that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, they would not have been an necessary party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling in respect of the application by Nana Equia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Equia Owusu. Yeah, be serious. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
As we be serious, the application on the face of it is not different, and notwithstanding the submission of a friend of the court in the person of Godwin Eduji Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence, is before this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she's saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos.
Uh-huh.
Alos.
Yeah, you were there, so probably you.
Yes, alos. The application, my dear friend, far before you. If you look at all the exhibits which they have filed, my Lord should realize, what is all this? My Lord should realize that they have not, or they did not. What is this? They did not. No, our application. Our application. Yes. They did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, that, we hadn't reached that stage. And because
then direct me properly.
no, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
My Lord, the bottom line is that, let's say, even there was even a declaration, in quote, but there was none, in quote. If the collation is done and you won, it will be confirmed that indeed you have won.
No. The judge said it will not affect her.
No.
Anyway, it is not your writing. It's because you were there. That's why I wanted you to react.
There is no way that if you win an election, and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is true.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then...
So, my Lord, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion. If the applicants are agreed about the discretion so assigned by the High Court judge, their remedy lies in an appeal. And not you. My lords, we submit accordingly.
Thank you.
My Lord, just a quick, okay. My Lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My Lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
Authority to give him. I have authority to give him to go to an appeal. Is it there? And I will give it to him. Yes. 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 The authority is there, I'll give it to him.
The court will take a short break. All rise.
My name is Kusi. I work with the Ministry of Education. I'm a Ghanaian, and of course I have interest in this 2024-2025 elections. But going into this election, there are three important things that we need. The first thing is peace, the second thing is peace, the third thing is peace. Hashtag choose peace Ghana. Thank you.
Anointing that you have received abides in you, and because of that anointing that abides, you have been empowered. Our words will be with power, but our actions will also be with power. And as we go out to witness, we see challenges in the lives of people, we command a change and it takes place.
It's that time of the year again. As the year draws to a close, God's children come together in faith, worship, and divine fellowship. Welcome to the 2024 camp meeting of the Gospel Ambassadors Church International. Theme: The Pursuit of the Heavenly Vision, inspired by Acts 26:19. Ministering: Reverend Simon Ampofo, General Overseer, Gracefields Chapel, Ghana. Reverend Dr. Peter Andobrako, General Secretary, Gospel Ambassadors Church. Reverend Steve Mensah, General Overseer, Charismatic Evangelistic Ministry, CEM. Reverend Apostle Frank Osei, General Overseer, Victory Charismatic Chapel. And your host, Reverend Ebenezer Yamwaganza, General Overseer, Gospel Ambassadors Ministries. Date: Friday, 27th December to Tuesday, 31st December 2024. Experience powerful teachings, spirit-filled worship, and life-transforming encounters with God. Mark your calendar, spread the word, and join us for an unforgettable experience of faith and renewal. The Gospel Ambassadors Church 2024 Camp Meeting, the pursuit of the heavenly vision.
My name is Abina, and I'm a mother of 2. My husband, Kwejo, whom I like to call my first son, likes to enjoy himself after work. My daughter, Nanekia, loves nature and flowers. She wants to become a florist in future. As a result of these, they are always exposed to parasitic worms. And because I'm aware of the harm the worms can cause the human body, I protect my family with Z400 albendazole. Z400 is effective against worms such as tapeworm, roundworm, and hookworm, and it comes in the form of syrup and tablets. Z400 albendazole is good for both adults and children from 2 years and above. Z400 albendazole, good protection for the whole family.
Not recommended for pregnant women and lactating mothers.
This advert is FDA approved.
Hello and welcome to Joy News today. I am Emefa Akosia Adeti. The bulletin is live from our studios here in Kokomlemle, Accra. And we're also live on DSTV channel 421 and GoTV channel 125 in our top stories this hour. Now, the Supreme Court today is set to deliver a decision on the National Democratic Congress challenging against the High Court ordered re-election or recollation. We take you to the Supreme Court, or we took you there. We shall bring you more details.
Who want to work with the rule of law, but you cannot go and sit in a room and go and collate figures when we're not there. We were told specifically by the director of elections in Domi-Kwabena, the boss of the returning officer who announced it, that because the place was unsafe, I'm sure you saw on TV, thugs, some getting on some people's backs or entering the place, going to create mayhem. And the EC suspended it and said all parties will meet at the region the next day.
We've been bringing you live coverage of the Supreme Court proceedings, which shall go back as and when there's an update. However, the New Patriotic Party stalwart and spokesperson for former President John Ejikun Kufuor is pointing fingers at President Akufo-Addo, saying he is partly to be blamed for the party's defeat in the 2024 general elections. We'll bring you details as 6 people, including 3 women, were injured in a collision between a truck and a Range Rover near the KNUST police station in Kumasi.
Eric, okay. Yeah, on the road national. I buy no brand and start by me because Range Rover V8 for no. I'm driving recklessly. Road national.
Also in the bulletin, fire raises local TV station and church at Crowfrom in the Ashanti region. Please stay with us for details. Welcome back and many thanks for choosing us. Now 6 people, including 3 women, have been injured in a crash involving a truck and a Range Rover near the KNUST police station in Kumasi. The truck carrying tomatoes from Burkina Faso collided with a Range Rover and crashed into a ditch. Mohammed Nuruddin spoke to the affected traders at the scene.
Namokwe.
Yeah, if you the money free waga bank. Burkina. Any bank. I'm doing
Me never follow you in a customer.
From an Amaya. I go just free Burkina. Yeah, you do take Yana. That police station. Naka cross over. Anna, you did come. So I need to know. I'm a grandpa driving in the crowd. Yeah, you. Today, I saw my name. I can't do. You see, over my am what? Already, I can't do. It's so much. Any papa 5. And I got on here, man. And yet, I can't get to. I have billions of cities.
Basically,
almost 4 billion. 4 billion because of that way. It's one way. But could be 1,300. 1,300 now. If I never 350. Nakamaku 350. I ain't get one. Tiafanakamaku 350. But could be 1,300. Oh, and silent duty. Silent transportation. Account. Nakao beto. Nipa do mko niema be pray. Se se die. E man ye una man. To si form my won kokodi. Ko we na tie. Afi ye una man. Ya kura e bi sit. O we ne kase ana tungo ko. Tie srawa. Samu bi fi. Mumla me shaye. Mama boy. Neni panso a pula no. Ye nya sika. E fa she. Omo pula.
Eric Ejabe.
Okay.
Yeah, on the road national. I buy no brand and start by me because Range Rover V8 for no. I'm driving recklessly. road no so. Yes, Ramunti, Omumbra and Sabamu, no Mumbra Meshe say, a Kwansu Jojo, ebe Juma, because driver no on your mistake be out. Now so Range Rover if you baby ba. About cross nama, Uyene Kesiato, Yaman, yes, Remu. Omumbra and Sabamu, Nombra Meshe Pana so, Nombra me boy, because he's here, Adia Yapana, Aton Coco for.
More car they meeting. Driver no driving a careless no boy. You one but I'm fat. A car man abon more than 4.5 billion. Lord for Mario in Chia. Master Yenia. More my drive for the same chicken free Kumasi. A drive no driving in. Yes, Ramwa. I'm going to meet you. I'm learning from me. 3 days in the night. A bombing 3 days in Timiko. I first was Minyaska. Menya prepare me. Many man now. Say for question but me na yira. No. Ghana you need to. Ghana you need be. Aye yeah, obvious ni. Obvious. But kai to from Kumasi.
Now, a local television station and church have been razed by an inferno at Krofrom, a suburb in the Ashanti region, capital Kumasi. The cause of the fire is yet to be known as the fire service commences a preliminary investigation to determine what may have caused the inferno. No casualty so far has been recorded, but properties worth thousands of cedis have been reduced to char. Apostle Collins Bwedi is the owner of the Trinity Television and has been recounting the incident to my colleague Emmanuel Bright Kweko. Now, my colleague Emmanuel Bright Kweko is our man on the beat and will join us via Zoom. Emmanuel, tell us what's been happening and when did this start?
All right, so MFR, we had an indication that this fire started about somewhere 9 a.m. just this morning. According to Mr. Apostle Collins Bwedi, who is the owner of this particular facility and the church and the local television, he tells me that they had started or they were done with their morning service or broadcast of morning service on television when they saw a fire in a kiosk, or if I should put it, a metallic container structure beside the church. And once they realized that it started, all of a sudden, it just went into their premises as well. And so they could not douse the fire. And they don't really know the cause of the situation, but he tells me from hearsays, they are saying that it started from a candle, others are saying weed and all of that. But until the fire service can actually ascertain the cause, we do not want to lay emphasis on what really started the fire. But some properties worth thousands of cedis have been destroyed by this particular fire incident at Krofrom in the Ashanti region. In the building, when I spoke with the owner, he tells me that it's a local television, just like we have for the multimedia group. So you should expect some cameras, some studio being destroyed, and also the church parts. That is, you having your drums, having a pulpit, having chairs, and all of other properties in there. I actually saw a Bible get bent just about now. They just gouged it and they were able to salvage that from the fire. But everything that was inside that building, what you see behind me, have been destroyed by this inferno at Krofrom. Another thing that we picked up was that when the first fire tender came, the residents here attacked it, so it could not come to douse the fire. So it went until another fire tender from Remain UGC came. So the first fire tender was coming from the Konfanochi Teaching Hospital area. When it came, the residents were furious and that they had kept long. According to my sources here, they say they had kept long. So they had to attack the fire tender. So the fire tender could not come and to douse the fire until a second fire tender came. And then that was able to douse the fire. But in there, you can see a little bit of smoke coming, and some plumes of smoke coming from the building itself. I don't know if you can see it around, but there is some smoke from there. They are trying to douse the fire completely. And we have some men also salvaging the little they can, and the metallic structures, the woods, and the rest. and put it. So still we have the fire service officers around and trying to ascertain what the real cause of the fire is.
And so as of now, we do not know the real cause, though the second fire tenders have been on location. We don't know the cause yet.
Yes, please. We do not know the cause.
At the time that they were attacking the first set of fire tenders, was the fire still ongoing, the outbreak still ongoing?
Well, sadly, from the residents, it was still ongoing. The fire was still high when the first fire tender came. So it had to return back until they called the second one, and the second one came to douse the fire.
Right. Before I let you go, just clarify. So it's a television station and a church as well in the same building?
Yes. So, some of these churches now, they broadcast on television. So sometimes they have, in the church itself, they have a studio set up where they broadcast to their members. And so it is a church and has some sort of a setup that they broadcast through television to the rest of the world, or even their audience and congregation at home. So they said they were having a church service. They had completed the first church service or broadcast, and then they later saw that a kiosk by them had set ablaze.
Well, that's sad to know. Thank you, Emmanuel, for bringing us that report from the Ashanti region. Now, moving on, spokesperson for former President John Agyekum Kufuor and New Patriotic Party stalwart Frank Agyekum says President Akufo-Addo is partly to blame for the party's loss in the 2024 general elections. The NDC's John Mahama defeated the NPP's Muhammadu Bawumia by over 1.6 million votes. According to Frank Agyekum, public disenchantment with the party coupled with arrogance from some members drove many supporters away. He also cited the imposition of unpopular candidates on constituencies as a factor that contributed to the significant defeat at the polls, adding that these issues unfolded under President Akufo-Addo's leadership.
Certainly, the buck always starts with the leader. I mean, you can't get away from that. When it's good, you take it, and when it's bad, you have to take it. So certainly, it starts with him. But then beyond that also, if you look at the performance of the candidate himself, especially in the parliamentaries, where at the constituency stage, the MPP parliamentarians pulled a lot more votes than he did, also tells you that perhaps he's not that popular with the people as it is. I mean, yes, the head of state, Akufo-Addo, has his share of the blame for not ensuring that some of the things that were done must have been done properly. But also, I don't think he should carry it all, because when you look at the personality of the person that went in and his votes, especially at the constituency, where you could say it was a vote between
So here, when you say his votes, are you talking of Dr. Bawumia? Are you talking of Dr. Bawumia here?
Yes.
Okay.
Yes. If you realize, for instance, even in 2022, when the party performed so badly, President Akufo-Addo's votes were more than those collective votes, were more than that of the all the MPs' votes put together. So that tells you that even then he was quite more popular than the MPs individually or together. But here now there's a reverse in where you can see that the MPs have gotten more votes totally against the candidates. So that itself tells a story, as to how popular he was with the people.
Now, the Supreme Court has been hearing the application for judicial review filed by the opposition NDC today. The case contests a December 20 High Court ruling that directed the Electoral Commission to recollect parliamentary election results in 9 disputed constituencies. The High Court ruling stemmed from a mandamus application filed by NPP parliamentary candidates in the affected area. The court ordered the EC to fulfill its constitutional obligation by verifying the recollected results in the contested constituencies. The NDC, however, has fiercely opposed the ruling and the recollection process, labeling it illegal and baseless. According to the party, the High Court exceeded its jurisdiction and undermined transparency, procedural fairness, and the integrity of the electoral process. So far, the EC has recollated results in 7 of the 9 constituencies, with Dom Kabinya and Ablikuma North still pending. My colleague Blessed Soga is our man in court and joins us with more. Blessed, bring us up to speed with proceedings. We shall try and connect with Blessed, but Blessed, if you can hear me, bring us updates from the court.
That an earlier ruling by the High Court asking for the recollation to be done by the Electoral Commission amounts to injustice on the part of some 8, I believe, or more candidates from its party, which were initially, according to the NDC, supposed to have been declared as winners of the contest in the just-ended presidential and parliamentary elections at various constituencies across the country. But the NPP has been arguing all day, indicating to the Supreme Court why it believes that the NDC has no case and that these recollated figures reflect the will of the people. The Electoral Commission, through its lawyers, also had representation throughout the day, which you have seen on your election headquarters on the Joy News channel, what has been going on in court. We're taking a break, of course, now waiting on what the court will say, but there's a number of reactions greeting this very decision and proceedings from court, including some candidates themselves. Baba Sadiq, who spoke to us a couple of minutes ago, indicating that he is hopeful that this will now be overturned so it can go in their favor. But one person also from the NPP camp is with us, Nana Asafuaje, who's just won the Bosome Freo seat. He will be the incoming member of parliament for that constituency, and he's joining us. Thank you so much, sir, for your time here on Joy.
Thank you. You're welcome.
And first of all, congratulations. Obviously, you've been in the ranks of the party for quite some time, and so congratulations will be in order. But let's talk about what's happening in court today. First of all, your impression about the arguments we've heard from both sides so far.
Okay, so the case is simple. I mean, maybe because of the gallery, because of the media, the justices will want to allow some of the arguments to hold on. Hitherto, this is a case of, this is a matter of legalities. An order of mandamus directing specifically a state institution to perform his duty. What is wrong with that? The state institution, in the courts, in the constitution, clearly it is the Electoral Commission that conducts elections. When the Electoral Commission conducts election, it is the responsibility of the Electoral Commission to declare same. The Electoral Commission is telling you that I have not declared. You are saying he has declared. I mean, who does that? The Electoral Commission is telling you that the Constitution, the rules, the CI upon which I am working with, clearly, I have not declared the result for the following constituency.
But Nana, to be fair, I guess that's not what's before the court now.
No, hold on. I'm trying to let you understand. This is the whole merit of the matter. So, a party goes to court and asks the court to direct the Electoral Commission to perform his jurisdiction or his duties. The court grants him that go and perform your duties. Now, another party brings the matter to court again. That court, can you kindly put aside the duties that were performed by the parties that the constitution has mandated to do so? That is what we are discussing here.
Is that really the case? Because the NDC is not seeking to set aside the constitutional duty of the Electoral Commission. What they are seeking to do is to say that the directives from the court did not follow the natural, the rule of natural justice, a reason for which they were not heard. We've heard that.
But he has not argued that. He raised the issue of rejoinder. It has been thrown off. Arguably, it has been thrown off. So he has not argued that. And I'm asking you, I want to make the thing very simple because I'm not a lawyer. I'm listening and I'm trying to put logical reason into it. A body that is mandated by the Constitution says, I have not performed my duty. I cannot perform my duty because there are attacks, there are people, harassing me, violating me to perform my duty. So a party comes to court to ask the court to direct that body who is mandated by the constitution to perform his duty. The court grants him. He goes ahead to perform his duty, declares his result. You are coming back to say that the court should now set aside the duty. So when they said,
and once again, they're not asking that the decision be set aside. All they are asking is that they be heard. So let's move on. I want us to talk about what the implications are possibly for your party. Whatever the outcome will be today. Whatever the outcome will be today. How is the NPP going to strategize to make use of the numbers you have?
One, we believe strongly in what is happening. We believe that the court will uphold what the other court did. Now, we have lost a lot of seats. Very traditional, very stronghold, very typical MPP seats. We are not talking about them. You know, I can mention a whole lot of them. Adansia Sokwa, Akrofrom, these are strong MPP traditional homes. Brekum, we are not arguing them. So when we are set out to protect and defend these ones, it means we are certain that we won the seats. Now, like I gave you the last time in Tessana, when we vote at the polling station, the ballot is counted and the election declared at the polling station. Look, even it has been directed, and that was done by the result being posted at the polling station. So if you set out to go to other polling station, you will know who won the result in a specific constituency or an area. You will know. Yes. So we know, we believe that we've won the elections. Now, if I won Busime. Now, if somebody says that, look, I want us to recollate the result of Pusumik Frame, which is legal. We have a specific time somebody calls for that. Why should I be worried?
Okay, but I was asking the question about how the party will now strategize giving the seats.
We have won the seat. What strategy again? What strategy again? These are seats that we won.
Now, the EC is also set to take a decision on two outstanding constituencies, Dom Kwabenya and Ablekuma North. James Aveji is monitoring the procedure that's happening at the EC and will take you there. Hi, James. If you can hear me, what's happening? Has the EC started already?
The Electoral Commission is yet to begin that IPAC meeting to take that final decision. As you may see from the background, the EC's office is currently deserted. We've pitched camp here for a while now, and we've not seen any of the commissioners drive in or out of the EC headquarters. The place is currently silent. Nothing is happening. Now, the indication we are picking is that usually when some of these things happen and the decision of the EC is part of issues in court, the EC would want to wait to hear the final decision of the court before they make their next move. We also have the indication that some of the deputy commissioners are currently in the Supreme Court, also monitoring the proceedings in there. And so we're waiting for the Supreme Court to take a final decision on the case pending in the Supreme Court before the EC would give us an indication as to when exactly that IPAC meeting will be happening. I've been speaking to some of the political parties who also tell me that till now they've not had any official invitation from the Electoral Commission. And so we're waiting to see how that pans out. Just to refresh your memory, Dom Kwabenya and Ablekuma North are the two constituencies that the EC will be taking final decision on. They were supposed to be part of the recoalition that happened last Saturday, but that recoalition did not happen. The EC did 7 instead of 9 and suspended these two because Dom Kwabenya, as we know, had some 3 outstanding polling stations to be dealt with. The NDC said they've provided those 3 pink sheets to the Electoral Commission on Tuesday night's emergency IPAC meeting. One of them has a problem where the result for the parliamentary election has been entered on a presidential sheet. And so we are expecting the EC this afternoon to consider whether they will be accepting those results in addition to the 2 clean ones and use them to effect the final coalition of Don Kwabena. As far as Ablekman North is concerned, from the initial recoalition that declared Arabna Obing as winner, the EC did that with 219 polling stations instead of 281 they were supposed to use. And so they had to, the EC directed, and per the course direction, they had to come and recollate the rest of the 62 polling stations, outstanding polling stations. As at last Saturday's recollation, the EC returning officer have been able to verify some 25 of the outstanding 62, left with 37 polling stations more to be looked at. The NPP said they have digital pink sheets of those 37 polling stations, and so they'll be submitting that to the Electoral Commission. Although the NDC is already objecting the Electoral Commission's any move to accept those 37 digital pink sheets, they say that if that will be accepted, then the EC would have to consider a rerun of the election in that particular polling station. And so those are the key outcomes we are looking at as to whether the EC will accept the presidential parliamentary result that have been entered on a presidential pink sheet as far as one of the polling stations of Don Kwabena is concerned, and whether also they will be accepting the 37 digital pink sheets from the Ablekman North as will be provided by the New Patriotic Party. And so as soon as the Supreme Court case is pronounced, we'll get a clearer indication as to when exactly, what time the IPAC meeting will be happening for the EC to take these 2 key decisions, MFA.
Political parties have indicated that they haven't had any invitations to be at any IPAC meeting today. Will this mean that even after the Supreme Court is taking the decision or not, they will not be receiving sort of a demand to appear at the IPAC meeting or what? Or they know that it's taken as granted that once the decision is taken, they must come to the EC for any form of IPAC meeting?
So this would come in the form of an emergency IPAC meeting. For normal IPAC meetings, they usually have almost 24 hours notice. And so for a meeting that's supposed to happen today, they were expected to get notification from the Electoral Commission as of yesterday. And so if they don't get those 24-hour notifications, and in cases like this where the EC would have to depend on the decision of the court to convene the meeting, then this will come in the form of an emergency IPAC meeting. So the EC has that powers over the period to marshal the political parties within an hour or two to take this IPAC meeting. And so as soon as this decision is taken, within an hour or two, we would expect the Electoral Commission to issue that invitation to the political parties to converge in an hour or two. And in most cases, the political parties also know about this, and so they are usually on standby as soon as the indication comes from the Electoral Commission, they quickly move to the headquarters to have this meeting. And so however it may go, unless it is postponed as it used to be in some cases, an emergency IPAC meeting is expected to be called today by the Electoral Commission per their own promise to call this decision. So it's not too late at all. The day is still young to have an emergency IPAC meeting. For instance, on Tuesday, that emergency IPAC meeting happened at 6 o'clock p.m. Sometimes it travels all the way into 11 p.m. or midnight of the day. And so the day is still young. We expect that meeting to happen, MFA.
Very well. Thank you so much, James Saveji. And do trust us, we'll bring you everything that would happen both at the Supreme Court and also at the Electoral Commission office. We'll go for a quick break. Business is up next. Do stay.
If you're running the ring, now
Tank muna mujiji iskasa mukoto. Tank nuna eli kiama henyina afu. Ah, ono siye. So wait, ne papa. Na papa no pole eli ki. Pacho ebenyensi we. Ghana for. One number one plumber new. If you necklace, I want to tank the ones you have. So Syntex tank, mixture SINTEX. Syntex tank. And you pop. And leaky. It's me with the beer. Syntex tank. Color beer open. Size beer open. Yeah, ma. Syntex tank. The whole Ghana. You must 7 years warranty. Syntex tank. And you're strong. And you're tough.
Every day, people have money emergencies. Ma, I need my school fees emergency. Mommy, chop money emergency. Emergency. Catch it. I'm in rent emergency. Now, there's a new emergency.
Welcome back to Business on Joy News today. My name is Winston Taki. The Bank of Ghana has issued guidelines on management and measurement of credit concentration risks as an exposure draft to solicit comments and input from the banking industry and the general public. The following report has more.
As part of the supervisory review process and in line with the risk-based approach to supervision, the Bank of Ghana said it will assess the level of regulated financial institutions' credit concentration risk and the quality of its management and the extent to which regulated financial institutions consider them in their internal assessment of capital adequacy. The supervisory assessment will include, among the assessment of a risk management framework, and particularly whether the framework adequately captures credit concentration risk and is well embedded in the day-to-day management of the regulated financial institution. Among others, the Bank of Ghana will check risk and business profile of regulated financial institutions, including exposure to credit concentration risk, as well as business model and strategy, including structure of the balance sheet and the credit portfolio.
Moving on, the Social Security and National Insurance Trust, NIT, is advising employers to engage employees on ways of aggregating some benefits into salaries for improved living conditions. According to the Chief Executive of SNIT, Kofi Asafo-Mafo, this will support future pension payment since more contributions will translate into better pension payment.
These are issues that employees need to have discussions about with their employers. These are issues that are to be taken up by the unions to resolve for the future, for the very long term. The central point that we make as SNIT is that it is not the SNIT scheme that is offering you the poor benefits. In fact, what we've highlighted today is that the SNIT scheme is overly generous. The SNIT scheme is overly generous. What we need to understand is that the SNIT scheme is based on your basic salary. So if your basic salary is low, or a lower part of your, or let's say a small part of your total take-home pay is considered for your pension, then when you retire, you are going to have a problem. So that is the discussion that we believe should be had. So it's what you put in is what you get out. And as we highlighted, there are people who are earning significant amounts on retirement based on what they put in. So likewise, if you look at your basic salary, whatever figure is there, your pension will be a function of that. So we are effectively starting that discussion that to improve pension payments, we have to look at what goes in to the contributions to SNIT. I think that is the central point.
That's all for business. My name is Winston Taki. Up next is sports. Stay tuned.